Welcome everyone, this is Amer Mushtaq from UCounsel. Today we'll talk about restrictive covenants in an employment contract, and we will explain to you what is a restrictive covenant, what are different kinds of restrictive covenants that are usually seen in employment contracts, and then we will specifically talk about a non-competition clause in an employment agreement. This course is not legal advice. This is only for educational purposes. So if you have any specific questions regarding your issues, you should contact a lawyer or a paralegal or contact the Law Society of Ontario for a referral. What is a restrictive covenant? Very simply, a restrictive covenant limits an employee's ability to do something either during employment or at the end of employment, after employment, for a certain period. So it is restricting an employee to do certain acts. And what are those acts? Those are contained in the specific restrictive covenant that will be in the employee's contract. So what are some of the common restrictive covenants? The most common one is a non-competition clause. Another one is a non-solicitation clause, which is quite common in employment contracts. Confidentiality clauses are common in employment contracts. And if you are dealing with any intellectual property of the employer, then you may see restrictive covenants relating to intellectual property. Now, what is a non-competition clause? It simply limits competition with the employer. So if you are an employee, a non-competition clause basically limits your ability to compete with your employer while you're employed and even after your employment has ended, either by resignation or even by termination of employment. Most of the non-competition clauses do not talk about non-competition during your employment because that is sort of given. If you compete against or compete with your employer while you're employed, that is simply a breach of your employment contract. You have an underlying implicit duty to be faithful and loyal to your employer and work in the best interest of your employer. So if you're competing with your employer, then that immediately is ground for termination for cause and maybe an action against you for damages. So the most of the non-competition clauses deal with what happens after your employment is ended. But essentially what the non-competition clause is doing is limiting an employee's ability to compete with the employer. An example that I can give you here is, let's say that you are a dentist and you work as an employee or as a dentist for a specific company. They may have other dentists at that location, but you don't own that business. You are an employee in that business or an independent contractor in specific circumstances of your case. But let's focus on employment situation. So let's say you're an employee of that dentistry practice. So your employment contract may contain a non-competition clause that may limit your ability, for example, that once your employment is ended, to start your dentistry practice next door or within 500 meters of that old the previous employer's dentistry practice, right? So and the underlying reason obviously for the employer to have such clauses that the employer has brought you in, maybe has given you the opportunity to work and learn your skill or refine your skills, interact with customers and whatnot, and so the employer does not want you to, having acquired those skills and having acquired those relationships, walk out and then compete with the employer and diminish the employer's practice. So that's sort of the underlying rationale behind why you may see a non-competition clause in your employment contract. So a non-competition clause is limiting an employee's ability to compete with the employer in its essence. So what are some of the underlying legal principles with respect to non-competition clause? Let's go over these one by one. The fundamental legal concept that is at play here with respect to non-competition is that there are two legal principles. One is freedom of trade. We, in our democratic and capitalist society, we encourage competition. We encourage that people are entitled to earn their living in any legal manner that they deem fit, and that may include competing with others. And so there is a value of freedom of trade, freedom of your ability to earn your living the way you would like to, as long as it's legal. So that's one of the principles. But at the same time, there's another legal principle that businesses should be able to protect their legitimate business interest, and one of the legitimate business interests may be that you have hired someone to work for your company, you have trained them, you have given them knowledge, you have given them, ability to meet customers, know your customers and whatnot. So there is a legitimate interest maybe at play for that particular company or employer that you should not walk away and then take away their business, right? And so those are sort of the two competing principles that a court is considering when a court is deciding whether to enforce a non-competition clause or not. Now, with respect to the enforceability of non-competition clauses, I can tell you as of today, April 24, 2019, courts in Ontario and in Canada are extremely reluctant to enforce a non-competition clause, right? And so the general weight of our jurisprudence as it stands today is that if there is a non-competition clause, the courts generally do not like to enforce it, so then they will find ways to determine that the clause is unenforceable, right? So the court has, even though the court will rule upon it, remember that we believe in freedom of contract, right? So if you have agreed to a contract, the court is bound to enforce that contract unless that contract is not in breach of law in general or a specific statute, right? So there's a freedom of contract. So if you are agreeing to a non-compete clause, you're agreeing to it. So for the court to not find it enforceable, court has to use some other legal principles rather than saying that, even though you signed it, we're not going to enforce it. No, that's not the reason why the court will not enforce it. The court will have to find some other legal principles to say that even though the clause is there, we're not going to enforce the clause in its form because of certain legal principles, and we'll talk about it in our next slide. Now, another legal principle for a clause, a non-competition clause to be enforceable should be that the clause, the way it's drafted, it should be narrowly drafted. It has to be very clear. There shouldn't be any vagueness or ambiguity in the clause, and the clause should be reasonable. So those are sort of the three things that the court will consider when reviewing a clause for its enforceability. So what is the legal framework when there is a case before a court in which the employer or the former employer of that employee comes to court and says that here is the contract, it was properly signed, it was properly executed, it's enforceable, and here is the non-competition clause, and we want you, the court, to enforce it because our former employee is now competing with us? What is the legal framework that the court will use to determine whether that clause is enforceable or not? Number one, the court will look at the geographical limit in that specific clause. So let's take our dentistry example. Imagine that, for the sake of our example, that this specific dentistry practice was based in downtown Toronto. There's one office, one location, it's based in downtown Toronto. Now, and most of the clients, most of the patients that come to that dentistry practice are also, most of them are also located in downtown Toronto. So that's how that practice is operating. But the non-competition clause says that you, the employee, cannot compete against this dentistry practice anywhere in the GTA. Let's say it says nowhere within the Greater Toronto area can you operate another dentistry in competition with us. So the court will then examine this geographical limit very, very closely, right? And remember, the underlying principle is if they can find it unenforceable, they will try to make it unenforceable. So is that geographical limit reasonable? Whether it's clear, number one, if you say this is the radius, this is the Greater Toronto area, whatever the term that you're using, the court will see whether it's clear, it's unambiguous, and then whether it's reasonable. So if in this case, if the most of the business that is coming to that dentistry is within, let's say, 5 square kilometers of downtown Toronto, then the court will say, why is it reasonable for you, the employer, to say that you cannot compete against me in the entire GTA? That's fundamentally unreasonable, right? And the court may say that there are already, let's say, 20, 30 dentistries that are already in competition with you within the 5 square kilometers. And so you imposing a limit of 30 kilometers or 50 kilometers for the GTA is sort of unreasonable. So in that case, the court is now closely watching whether the limit that you're imposing, is that reasonable to begin with? And if that's not reasonable, most of your clients are within 5 kilometer radius, then any limit that is beyond 5 kilometer radius is going to be unreasonable. So the court will throw that clause out because the geographical limit is unreasonable. Then the court will look at the temporal limit. For how long is the employee required not to compete against the employer? So let's say in this dentistry practice example, you were the dentist, you worked with that dentistry for 5 months, but the temporal limit in your non-competition clause says that you cannot compete with that dentistry for 2 years. Now, is that a reasonable time limit with respect to the restraint on your ability to compete with the employer? And the court is then going to closely examine what should be an appropriate temporal limit, right? Because let me give you an example. So what you're saying in this case is, if you're saying that you cannot compete with me for 2 years, what you're saying is that, look, even though you know my clients and you know everybody and you know my business, in the 4 months that you dealt with, I cannot sustain my business for 2 years if you compete with me. So 2 years is a long time. So in some ways that suggests that you're so vulnerable and your ability to keep your clients as your clients is so weak that, even that dentist has left, a year ago, you're still worried that that dentist can take away your client, right? And so do you even deserve that business because you cannot compete in open market? So, there are all these considerations that the court will consider, but essentially the court is determining whether the temporal limit that is imposed in the non-competition clause is reasonable. And if it's not reasonable, it gets thrown out. So you can put in, as an employer, you can put in 5 years, 10 years, lifetime, whatever you want. But if the temporal limit is not reasonable, your clause is not going to get enforced. Then, third thing that the court is considering is what specific activity or activities are you prohibiting the employee, the former employee, not to do. So what is it that you're saying you shall not do? So one example could be that the clause may say you cannot open another dentistry practice, right? But what about dental hygienist practice? What if the dentist wants to just open a dental hygienist clinic and not have, not provide the services as a dentist, but as a dental hygienist, or just hire a dental hygienist to provide those services and run that business? Now, is that covered in that non-competition? Would the dentistry practice, the way it's defined in the contract, does that include dental hygienist practice? And if it does, then the question is that reasonable? And the court may say, no, that may not be reasonable. This former employee was working as a dentist, never competed with a dental hygienist business, and so it is unfair, unreasonable for you to limit the dental hygienist business. What if the employee just wants to open a shop which sells dental equipment? Is that in competition? So the court is looking at exactly what is it that the non-competition clause is saying that the employee cannot do. And is that clear? Is that reasonable? And if it's not, then the whole non-competition clause gets thrown out. So this is how a court will examine a non-competition clause and then determine whether to enforce that clause or not. Let's look at a non-competition clause just for the sake of it, so you can see what kind of non-competition clauses are out there. You may have a similar or somewhat different clause. There's no standard language for this. I just picked one to sort of give you a sense of what a clause can read. So here's a clause: you will not, for a period of 1 year. So the temporal limit here is 1 year, following the date of your termination or resignation. So it covers termination, dismissal with cause, without cause, or resignation. So in any circumstances, the time period is 1 year. What is it that you are not allowed to do as an employee? Directly or indirectly. Keywords, right? In any manner whatsoever, including without limitation, either individually or in partnership or jointly or in conjunction with any other person or persons, as principal, agent, shareholder, associate, or in any other manner whatsoever. Carry on or start your own dentistry practice anywhere within a radius of 10 kilometers of the company's premises, and or directly or indirectly in any manner whatsoever, including without limitation, work as an agent, associate, employee, independent contractor, or in any other manner whatsoever in a dentistry practice anywhere within a radius of 10 kilometers of the company's premises. So this is a pretty strict clause, right? It limits your ability to start your practice either directly or indirectly, or even work as an agent, associate, employee, or independent contractor of another dentistry. So is that clause reasonable? The court is going to look at it and then look at it closely, minutely, and then determine whether the temporal limit is correct. Is it reasonable? Whether the geographical limit is reasonable, and whether what activities are being prevented, is that reasonable, right? Another common part of this clause is this, that you acknowledge and agree that the company may apply for have an injunction. So injunction is really that if you start a competing business with an employer, can the employer literally go to the court, bring a motion for injunction, and stop you right in your tracks? And so this clause is saying basically that if you do compete with us, we're going to go bring an injunction against you and then stop you right there and then seek damages for and the legal costs and whatnot. And then it further goes on to say, if any covenant or provision herein is determined to be void or unenforceable in whole or in part, it shall not be deemed to affect or impair the validity of any other covenants or provisions, and such unenforceable or invalid portion shall be severable from the remainder of this agreement. This is a typical clause that if the court finds one clause to be unenforceable, the other clauses should continue to be enforceable. Notwithstanding the foregoing, if in any judicial proceeding any provision hereof is found to be so broad as to be unenforceable, it is hereby agreed that such provision shall be interpreted to be only so broad as to be enforceable. So this is sort of a try to say that, oh, if the court finds that, if we put a very broad limit on the geographical scope, then whatever interpretation will make it a bit narrower so that it can make it enforceable, let's go with that interpretation. It may not fly in court, but this is sort of the language that, you may find in the clause. And then finally it says, you, the employee, acknowledge and agree that all restrictions contained herein are reasonable and valid, and all defenses to the strict enforcement thereof by the company are waived. So this is sort of a typical clause. There may be other variations of it. We lawyers, spend a lot of time drafting these things because each and every word that is contained in this clause is subject to challenge, is subject to interpretation. And so if you want a clause like that to be enforced, you have to be very careful in how you draft it and to make sure that it is appropriately drafted so that it could be enforced in courts. Now, in conclusion, what is it that you want to remember? It is not easy to enforce non-competition clauses. So why do we lawyers even put it in the employment contracts when we draft it? Or why do companies put them in those agreements? For a variety of reasons, right? So one reason is simply strategic. It is there as a threat. You know that there's a clause in there that you have signed. It may sound ridiculously broad. It may sound unreasonable, but you have signed it. And if you try to compete with us, the company, we will take you to court. So you will at least, at the end of the day, when you're before the judge at trial, you may succeed, but we will drag you into the court fight and you'll have to spend all this money to prove your case, and that may be sufficient threat for you to sort of worry about the clause, even though when you read it, you realize that based on my lecture, you know that this clause would not have a day in court. But at the same time, there are practical implications of getting into a legal fight, and you don't want to be in that situation. Now, other part, if you're an employee, you want to keep this in mind. This is an important tip for you when you're negotiating your employment contract. When you see a non-competition clause in your employment contract and you're a smart guy, you have listened to my lecture, you've figured out that the clause is not going to be enforceable or not, is it worth it to even negotiate with the employer? Because if it's a badly drafted non-competition clause, it may be worth for you just to sign it because you know that it's not going to get enforced. You understand that. But if you raise this issue and you say to the employer, I don't want this non-competition clause, or the non-competition clause is too broad, and then the employer then gets into that negotiation and fixes that clause, right? Or does, puts it in a way that is actually going to be enforceable. Now you've put yourself in a difficult position for the future because now you have not only negotiated a non-competition clause, but you have, by raising this issue, put yourself in a position where the employer has drafted a clause that is actually going to be enforced against you. So you want to be careful, even though you read a non-competition clause, you understand it, you're comfortable that you're willing to take a risk on this non-competition clause because it's not going to be enforceable based on how it is drafted. Is it worth it to even negotiate? Think about that. Think about your negotiation power within that deal. If you don't have negotiation power, then you want to be careful about the issues that you raise in an employment contract. So I hope this gives you a sense of what a non-competition clause is, what restrictive covenants are in general. Restrictive covenants are very, very important. Why? Because they limit your ability to do something even when you have left the employment, right? And so that's why when you sign a contract, the most important thing you want to look at restrictive covenants. What is it that the employer is telling you you cannot do? See, when you have left the employment, you're not getting paid for that employment. You have to find another job, and yet you are bound by an employment contract with a previous employer. So is that something that you want to be worried about? That is something to consider. So restrictive covenants in employment are important. We'll talk more about it in our future lectures. We'll unpack each and every kind of restrictive covenant and then try to explain to you in more detail. Thank you for watching.